in defiance of this court. Your provisional measures order is another inconvenient topic for Russia. Yesterday, it said almost nothing about it. When Russia did acknowledge your order, Russia didn't hesitate to tell you that you were wrong. But Russia's opinion doesn't change its international obligations. Your order is binding. Russia openly defies it. This court now has the opportunity to reject such defiance. You have the power to ensure that international obligations are meaningful. You can decide that states that tirelessly abuse and misuse a human rights treaty will be held to account. You have the power to declare that Russia's actions are unlawful, that its continued abuses must stop, that your orders must be followed, and that Russia must make reparation. 1 year ago, President Volodymyr Zelensky said to the UN Security Council that in Ukraine, I quote, "Not only our independence is being defended, not only the right to life for our people, but also international law as such," end of quote. In this court as well, international law as such is at stake. Ukraine urges the court to reject Russia's abuse of international law. Ukraine asks you to ensure that the Genocide Convention remains a force for protecting human rights, not a means for denying millions of people their human rights. Yesterday, you heard Russia twist the facts and distort the law. Today, Ukraine will explain why this court can and must hear Ukraine's case on the merits. Professor Harlot Honjuko will first address the interpretation of Article 9 of the Genocide Convention and the broad jurisdiction it confers on this court. He will explain why Russia cannot escape this court's jurisdiction by mischaracterizing Ukraine's claims. Ms. Marnichik will then show that there is a dispute between the states relating to the Genocide Convention. Professor Jean-Marc Touvenin will demonstrate that this dispute falls squarely within this court's jurisdiction ratione materia. Mr. David Zients will address why Ukraine claims are admissible. Finally, Mr. Jonathan Gimblet will discuss this court's jurisdiction to address the Russian Federation's ongoing and flagrant violations of this court's order indicating provisional measures. Madam President, members of the court, on the ashes of World War II and the Holocaust, the world produced a landmark human rights treaty in the Genocide Convention. It reflects the highest ideals of humanity. A few months from now, the world will mark this convention's 75th anniversary. This can be an opportunity for the international community to recommit itself to the convention's civilizing aims and humanitarian purpose. But if Russia's abuse goes unanswered, this anniversary will be a dark one. Can it truly be the case that a state can abuse the Genocide Convention to justify a war of conquest? Can a state use false allegations of genocide as a pretext to destroy cities, bomb civilians, and deport children from their homes? And when the Genocide Convention is so cynically abused, is this court powerless? The answer to these questions must be no. It must be no for the sake of the Ukrainian people, who remain under brutal attack. And it must be no for the sake of the world, to prevent international law from being twisted into a tool for human rights abuses and destruction. Ukraine is grateful for the court's attention this morning. Madam President, I now kindly ask you to call Professor Ko to the podium.
I thank the agent of Ukraine for his statement, and I now give the floor to Professor Harold Hong-Juko. You have the floor, Professor.
Madam President, members of the court, it is again my honor to appear before you on behalf of Ukraine. In February 2022, shortly after Russia's full-scale invasion, Ukraine brought before you this dispute relating to Russia's false allegations to justify its unilateral actions in and against Ukraine on the pretext of preventing and punishing a genocide. When Russia ratified the Genocide Convention in 1954, it consented to this court's jurisdiction over any dispute relating to the interpretation, application, or fulfillment of the convention. Yesterday, Russia's counsel denied that there is an ongoing dispute that brings this case within Article 9 of the convention. Russia takes one position. Because Ukraine is responsible for committing genocide, they say, it must use military force to prevent and punish that alleged genocide in violation of the convention. But Ukraine takes the opposite position. It strenuously disputes Russia's outrageous claims, rejects Russia's claimed right and duty to use force to stop this claimed genocide, and shows that it is Russia that has abused, misused, and violated the convention by invading Ukraine on the pretext of genocide prevention. Yesterday, in their oddly antiseptic presentation, Russia's counsel repeatedly denied that it had invoked the Genocide Convention to authorize the use of force. But they ignored President Putin's own words launching the invasion, where he explicitly declared the purpose of this special military operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kyiv regime. To this end, Russia will seek to demilitarize and denazify Ukraine, as our agent has just recounted, by using brutal force for the last 19 months. As defined in Mavromatis, a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between two persons over which this court may exercise jurisdiction. Here we clearly have such a disagreement relating to the interpretation, application, or fulfillment of the convention. So under Article 9, that brings this case squarely within your jurisdiction. When we first appeared before you last March seeking provisional measures, this court found by a vote of 13-2 that in the court's view, the acts complained of by Ukraine appear to be capable of falling within the provisions of the Genocide Convention. Upon closer examination, this court's prima facie ruling was plainly correct and should lead you now to dismiss Russia's preliminary objections. Dismissal is required first because of Article 9's distinctively broad scope, which reflects the importance and purpose of the Genocide Convention itself. Second, because Russia cannot avoid the court's manifest jurisdiction by grossly mischaracterizing Ukraine's claims, ignoring settled jurisprudence, and asking you to disregard the facts and evidence Ukraine has offered and will prove at the merit stage. Madam President, members of the court, the treaty's text, object and purpose, negotiating history, and historical context all show that Article 9 was intended to grant the court jurisdiction over the widest range of disputes relating to the Genocide Convention, including this dispute. In their presentation yesterday, Russia's counsel glided over the specific and distinctive language of Article 9, the Convention's dispute settlement provision, which you see here. Russia ignores 4 ways in which Article 9 is both distinctive and broader than other such clauses, because the Genocide Convention is a broad and distinctive treaty. First, and most obvious, the clause does not confine itself to cases concerning interpretation or application of the treaty, as many such clauses do. It also includes disputes relating to whether and how parties like Russia have fulfilled their treaty obligations. During the drafting debates, after the Indian delegation made clear that fulfillment has a much wider meaning than application, the delegations defeated a proposal to delete fulfillment, confirming their intent to adopt the broadest formulation possible. The Oxford English Dictionary defines fulfillment as accomplishment, performance, completion. In French, Larousse defines l'exécution as the performance or accomplishment of an obligation. So adding the word fulfillment to the familiar template of interpretation and application was designed to ensure that the court's jurisdiction would reach disputes relating to the ways in which the contracting parties, like Russia, perform or accomplish their obligations under the convention. When Russia invaded Ukraine last February for the pretextual reason of stopping a genocide, it failed to perform in good faith. In fact, it abused the convention. Contrary to what Russia's counsel asserted yesterday, this case differs significantly from the legality of use of force case, where no party stated before the court that the use of force by the respondent states had the purpose of preventing an alleged genocide. In contrast, as Judge Nolta observed in his separate declaration to the Provisional Measures Order, Russia has in the present case, quote, made allegations that Ukraine is committing genocide and has affirmed that its special military operation serves the purpose of preventing genocide, thereby, quote, acting in a way that is capable of coming within the provisions of the Genocide Convention. So the plain text of Article 9 thus authorizes this court to review Russia's violations of the Genocide Convention on the merits. To be clear, this is a dispute not just about the convention's fulfillment, but also about its interpretation and application. This dispute is about interpretation because the parties disagree about the meaning of their respective legal rights and obligations under the convention. This dispute is about application, as the Chorzo factory case explained, because application includes disputes related to whether the application of a particular clause has or has not been correct, and whether a state has created a situation contrary to said articles. Here, Russia has clearly misapplied the convention by abusing the text and purpose of this treaty to launch an unlawful military invasion. So even if Article 9 had the same narrower scope as many other compromissory clauses, this dispute would still fall squarely within it. But the unusual addition of the word fulfillment gives Article 9 its distinctively comprehensive sweep, placing this court's jurisdiction beyond any doubt. Second, Article 9 extends jurisdiction to disputes relating to the interpretation, application, or fulfillment of the convention. It does not require that treaties' interpretation, application, or fulfillment alone be the subject matter of the dispute. The ordinary meaning of relate, as defined by the Oxford English Dictionary, is to have a connection with something. In the Yakimets case, which addressed whether the UN Administrative Tribunal had erred on a question of law relating to the provisions of the UN Charter, Judge Schwabel explained that such an error need not squarely and directly engage a provision of the Charter. It is sufficient if such an error is connected with the Charter. Here, Russia's pretextual allegations that Ukraine committed genocide in violation of the Convention, which Russia used as its basis for violently invading Ukraine, obviously are connected with, that is, relate to, the responsibility of a state for genocide, genocide prevention, and genocide punishment. Third, Article 9 specifies that it includes those particular disputes relating to the responsibility of a state for genocide. As this court observed in the Bosnian genocide case, this clause is an unusual feature of Article 9, you said, The word including tends to confirm that disputes relating to the responsibility of the contracting parties for genocide are comprised within a broader group of disputes relating to the interpretation, application, or fulfillment of the convention. That broader group of disputes would include, for example, the questions relating to responsibility for genocide here. Is Ukraine, as Russia alleges, really responsible for committing genocide? Or is it Russia that violates its duties under the convention by falsely alleging that Ukraine is committing genocide, then invoking that pretext to invade and brutalize its sovereign neighbor? Fourth, Article 9 specifies that any of the parties to a dispute under the convention may submit it to the court. Article 9 imposes no preconditions, leaving no doubt. It was meant to ensure broad access to the court. So, if, as Russia acknowledges, a state that levels allegations of genocide against another can ask the court to resolve that dispute, there is no reason why a state such as Ukraine that disputes allegations of genocide against it and illegal actions based on pretextual allegations cannot do the same. Article 9's four unique textual features were not accidental. As Professor Kolb describes in the Gaeta commentary to the Genocide Convention, the drafters deliberately decided to close down all possible loopholes, weakening the jurisdictional reach of the court, so as to grant the court as wide a jurisdiction as possible in the life of the convention. But yesterday, Russia asked you to undo that careful drafting decision by narrowing what the drafters meant to broaden and reopening the very loopholes they meant to close. As the written interventions of the intervening states confirm, the intentional breadth of this court's jurisdiction flows not just from the expansive language of Article 9, but also from the Genocide Convention's broad object and purpose. Genocide is the worst crime in international law and human history. It is the ultimate crime, the kind of horrible, intentional effort to destroy an entire national, ethnic, racial, or religious group that we have witnessed all too often in our collective past. The Convention's preamble sets out its historic purpose as a good faith endeavor of international cooperation to liberate humankind from this odious scourge. As this court stated in its landmark 1951 advisory opinion, the Convention was manifestly adopted for a purely humanitarian and civilizing purpose. Conferring broad Article 9 jurisdiction on this court helps to achieve that object and purpose, which yesterday Russia's counsel claimed that, quote, Russia stands by. A genuine good faith determination that genocide or a serious risk of genocide exists may empower preventive action consistent with international law, which must not be exercised lightly. Because along with that power comes the responsibility to avoid abusing it and degrading the jus cogens norm against genocide that the Convention protects. States offend the object and purpose of the Convention when they ignore a genocide that is clearly occurring, but also when they falsely allege a genocide that is clearly not occurring, not to achieve the Convention's humanitarian purposes, but to seek license to illegally attack and invade another state. Both kinds of disputes unmistakably relate to the interpretation, application, and fulfillment of the Convention, including the responsibility of a state for genocide. The extreme facts of this case show the grave danger of allowing Russia to subvert the Genocide Convention's noble purposes. Article 9 gives this court a crucial role, not just when a state violates the Convention by committing genocide, but also when it misinterprets it, misapplies it, or falsely claims to fulfill its treaty obligations by inflicting grievous harm on a neighboring nation and people. The many interventions that you will hear tomorrow announce that this case is far bigger than Ukraine versus Russia. It is about what the world's most important human rights treaty really means, how it may be lawfully used, and whether this court is powerless when that convention is flagrantly abused. Madam President, members of the court, Russia's presentation yesterday sought to avoid Article 9's broad sweep by mischaracterizing this dispute as one that relates to whether Russia's recognition of the so-called Donetsk and Luhansk People's Republics complied with customary international law and whether its use of force against Ukraine complied with the UN Charter. But we all know Russia only took those actions on the pretext that the invasion of Ukraine was necessary to prevent and punish genocide. The real dispute that Ukraine has put before you, not the one that Russia has manufactured, relates to the questions of interpretation, application, or fulfillment of the Genocide Convention raised by Russia's invocation of its false allegations to justify its pretextual unilateral actions, including sham recognition and use of force and atrocity in the name of self-defense. Ukraine claims that Russia violated Article 1 of the Convention by acting on the false allegation that Ukraine committed the international crime of genocide, which Russia became obliged to prevent and punish. Ukraine further claims that Russia violated Article 4 by invading Ukraine to punish a genocide based on false allegations that Ukraine officials are persons committing genocide for purposes of Article 4. At this preliminary objection stage, this court, not Russia, must isolate the real issue and objectively determine the subject matter of the dispute, taking particular account of the facts on which Ukraine, as applicant, rests its claim. Russia may disagree with Ukraine's position on the merits. It may wish to defend its outrageous allegations that Ukraine and its officials committed genocide. It may wish to deny that these allegations had anything to do with its brutal, full-scale invasion. If so, Russia can make those empty arguments at the merits stage. But for now, these merits arguments are irrelevant to the only thing that matters at this stage. Ukraine and Russia undeniably have a dispute over which this court has jurisdiction under Article 9. Yesterday, you repeatedly heard Russia justify its actions under customary international law or Article 51 of the UN Charter. But it does not matter whether Ukraine and Russia also have a dispute that relates to other sources of international law. As this court recently made clear, certain acts may fall within the ambit of more than one instrument. And as this court elaborated in another case between these same two parties, the fact that a dispute before the court forms part of a complex situation that includes various matters, however important, over which the states concerned hold opposite views, cannot lead the court to decline to resolve that dispute, provided that the parties have recognized the jurisdiction to do so. Madam President, members of the court, in a great many cases, you are asked to decide close and difficult questions. But this is not one of them. When we first met here at the Provisional Measures hearing, you clearly understood the dispute before you. Ukraine charged Russia with launching a full-scale invasion of Ukraine on the pretext of preventing and punishing a claimed genocide that transparently is not occurring, and invoking a convention that conferred no lawful authority upon Russia to invade Ukraine, kill its citizens, and destroy its homeland. Russia acted and continues to act based on false allegations of genocide against Ukraine and twisted readings of the law, both of which Ukraine disputes. Simply put, Ukraine and Russia have a dispute relating to the interpretation, application, or fulfillment of the convention that this court must decide. Russia's allegations and actions give rise to this court's jurisdiction, full stop. Accordingly, This court should dismiss Russia's preliminary objections and proceed to the merits. Madam President, I now ask you to call Ms. Cheek to the podium to explain why Russia's first preliminary objection should be dismissed.
I thank Professor Coe, and I now invite Ms. Marnie Cheek to address the court. You have the floor, Madam.
Madam President, members of the court, it is an honor to appear again before you on behalf of Ukraine. This morning, I will address Russia's first preliminary objection regarding the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. Russia's first preliminary objection should be rejected. In the first instance, Russia is wrong on the law. Russia has departed from this court's test to determine whether a dispute exists between the parties. That test focuses on the parties' opposing views regarding the subject matter of the treaty. Second, Russia is wrong on the facts. The evidence before the court confirms the existence of a dispute between the parties relating to the Genocide Convention. There is no question that at the time of Ukraine's application, the parties held opposing views on Russia's reliance on allegations of genocide to justify its unilateral actions in and against Ukraine for the stated purpose of bringing an alleged genocide to an end. I will first turn to the legal test this court applies to determine the existence of a dispute between the parties. The legal test is well settled, and normally we would not need to spend much time on it. But Russia has urged the court to adopt a radically different approach, and it is therefore worth taking a few minutes to clarify the standards that have been consistently applied by your court. Yesterday, Russia's counsel focused on the submissions in Ukraine's memorial and asked this court whether a dispute between the parties existed as to each of those submissions. But respectfully, this is the wrong approach. Ukraine's application invokes a single treaty, the Genocide Convention, and the question before the court is whether a dispute exists regarding the subject matter of that treaty. The standards the court applies to determine whether a dispute exists regarding the subject matter of a treaty are well established. The court has consistently emphasized that the existence of a dispute should be determined objectively on the basis of the facts before the court. The existence of a dispute is a question of substance, not of form or procedure. And such an assessment takes account of the statements of the parties as well as the parties' conduct. The court has consistently applied these standards. They are set out in Georgia versus the Russian Federation, Marshall Islands versus the United Kingdom, and alleged allegations, Nicaragua versus Colombia, to name a few. It is of particular note that the court recently applied these standards in its judgment on preliminary objections in the Gambia versus Myanmar, a case also under the Genocide Convention. Now, Russia does embrace some aspects of the court's settled jurisprudence, observing that a dispute exists where, quote, the claim of one party is positively opposed by the other, and, quote, a dispute exists when the respondent was aware or could not have been unaware that its views were positively opposed. At the same time, however, the Russian Federation seeks to impose novel requirements, many of which this court has considered previously and rejected. Russia's main argument is that at the time of Ukraine's application to this court, Ukraine's legal claims must have been identified with exacting specificity. This is the foundation of Russia's first preliminary objection and was echoed yesterday as Russia's counsel took you to the submissions in Ukraine's memorial, rather than focusing on the subject matter of the Genocide Convention. Russia asked this court to focus on whether Ukraine articulated specific legal claims under the Genocide Convention, ignoring whether a dispute existed relating to the subject matter of the convention. Russia argues, for example, that, quote, Ukraine must demonstrate that an dispute existed with respect to each of the claims formulated in the memorial at the time that Ukraine filed its application. Russia also suggests that the evidence of a dispute must reflect quote, positively opposed views with respect to the specific obligations under the convention. But the court has previously rejected that proposed test. In the Gambia versus Myanmar, Myanmar argued, as Russia does here, that statements made prior to the Gambia's application did not specifically articulate its legal claims. As Russia does now, Myanmar argued that prior to instituting proceedings, the applicant must have identified the provisions of international law that have been breached. Your court rejected this argument. The court explained that it, quote, does not consider that a specific reference to a treaty or to its provisions is required. The court went on to say that a state must only, quote, refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is or may be a dispute regarding that subject matter. Contrary to Russia's presentation yesterday, the focus of the court is on the existence of a dispute with regards to the subject matter of the treaty. Russia's allegations of genocide against Ukraine and its unilateral actions for the stated purpose of bringing that genocide to an end fall squarely within the subject matter of the Genocide Convention, the commission of genocide and the prevention and punishment of that heinous crime. This court has consistently found the existence of a dispute in a wide range of circumstances. In the Gambia versus Myanmar, for example, the Gambia had made two statements before the United Nations, neither of which referred expressly to the Genocide Convention, which this court found were opposed by Myanmar and sufficient evidence of the parties' dispute under the convention. In Georgia versus the Russian Federation, Georgia never expressly referred to the Convention on the Elimination of All Forms of Racial Discrimination in exchanges between the parties before Georgia seized the court under that treaty. Nevertheless, the court concluded that Georgia's statements made in the course of Russia's August 2008 invasion, though, quote, primarily claims about the allegedly unlawful use of force, also expressly referred to allegations of ethnic cleansing by Russian forces, end quote. The court found that Georgia's statements referring to ethnic cleansing in this context were sufficient evidence that there was a dispute under the CHRD. In short, this court has established that when determining whether a dispute exists, the focus is on whether there were communications regarding the subject matter of the treaty at issue. The parties do not need to refer to the treaty by name. There is certainly no requirement to expressly reference specific treaty provisions or legal sections. Perhaps realizing the weakness of this principal legal argument that Russia puts forward, Russia attempts to erect a series of additional technical legal hurdles. But these efforts similarly run afoul of the court's jurisprudence and should therefore be rejected as well. First, Russia argues that a dispute between the parties relating to the Genocide Convention cannot exist because Russia never formally invoked Ukraine's responsibility for genocide under the convention. On this basis, Russia asked the court to simply disregard Russia's statements accusing Ukraine of committing genocide and Russia's express reliance on those allegations to justify its recognition of the DPR and LPR and its full-scale invasion of Ukraine. Russia claims to find support for its argument in the International Law Commission's articles on responsibility of states for internationally wrongful acts, which Russia also referenced yesterday. But the commentaries to the ILC articles on invocation of state responsibility specify that they, quote, are not concerned with questions of the jurisdiction of international courts and tribunals, or, in general, with the conditions for the admissibility of cases brought before such courts or tribunals. The court also rejected the respondents' reliance on the ILC articles in Marshall Islands, observing that, quote, the court's jurisprudence treats the question of the existence of a dispute as a jurisdictional one that turns on whether there is, in substance, a dispute, not on what form the dispute takes or whether the respondent has been notified. Similarly, the court should reject Russia's novel proposal in this case. Second, Russia asks the court to ignore the conduct of the parties. Specifically, Russia asks the court to ignore Ukraine's conduct, demonstrating its rejection of Russia's claimed right to invade Ukraine for the stated purpose of preventing and punishing a genocide. But this court has previously confirmed that the conduct of the parties may be relevant to its assessment of whether or not a dispute exists, particularly in cases where, for various reasons, there have been no diplomatic exchanges between the parties. For example, in Marshall Islands, in this court's discussion of Bosnian genocide, the court noted that, quote, in that particular case, which involved an ongoing armed conflict, the prior conduct of the parties was sufficient to establish the existence of a dispute. As I will shortly demonstrate, the parties' conduct in this case also underscores the existence of a dispute here. Simply put, Russia's attempt to erect as many legal hurdles as possible to this court finding the existence of a dispute should be rejected. To summarize, the court's jurisprudence is clear. The court looks objectively at the facts to determine whether, at the time Ukraine filed its application, a dispute existed between the parties relating to the subject matter of the Genocide Convention. The court does not require the articulation of specific legal claims by Ukraine in order to find a dispute. Nor does the court require that Russia must have formally invoked Ukraine's international responsibility under the Genocide Convention for this case to proceed. In making its assessment, the court should take into account both statements and conduct. With this in mind, we turn to the facts before you. Russia has repeatedly accused Ukraine and its officials of committing genocide in the Donbas region of Ukraine. Russia then relied on those allegations of genocide in February 2022 to recognize the DPR and the LPR and to justify Russia's full-scale invasion of Ukraine. Russia has made these accusations of genocide for years, sometimes referring expressly to alleged violations of the Convention, sometimes referring to the subject matter of the Convention without calling the Convention out by name. Russia cannot deny these statements, and so it claims they have no significance. The world was in shock when Russia launched its full-scale invasion of Ukraine in February 2022. But the steps culminating in that brazen use of force did not only include a buildup of troops along the Ukraine-Belarusian border. It also included 8 years of building a sham justification for Putin's so-called special military operation, allegations that Ukraine had committed genocide in Donbass that must be prevented and punished. This was not just political rhetoric, as Russia would like you to believe. I will now walk you through a bit of that 8-year history. You heard little yesterday about the investigative committee of the Russian Federation. Since 2014, the investigative committee has repeatedly and expressly alleged that Ukrainian officials, including 2 ministers of defense, have committed crimes under the Genocide Convention. The investigative committee has pursued criminal proceedings against Ukrainian officials based on alleged acts of genocide against the Russian-speaking population of eastern Ukraine. As you may recall, the investigative committee is a state organ of the Russian Federation, and it is supervised by the President of the Russian Federation. Let me highlight just a few specific statements made by Russia's investigative committee. You will also note that the committee repeatedly refers to the Genocide Convention by name. In September 2014, the committee claimed that, quote, violation of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, identified persons from among the top political and military leadership of Ukraine gave orders aimed to completely destroy, specifically the Russian-speaking population living on the territory of the Donetsk and Luhansk republics. In January 2015, the committee stated that the actions of top political and military leadership of Ukraine, quote, can only be qualified as genocide, and that such acts carried out by the Ukrainian military constitute especially grave crimes, not only under Russian law, but also under the norms of international law, in particular, the Convention on the Prevention and Punishment of the Crime of Genocide. In September 2017, the committee announced 20 criminal cases against Ukrainian officials, including the sitting Minister of Defense. It alleged that they acted, quote, in violation of the Convention on the Prevention and Punishment of the Crime of Genocide by giving deliberately criminal orders to shell civilian infrastructure. The committee stated that, quote, it is obvious that all of these persons acted out of hatred to the Russian-speaking population living in the Donbass, wishing them to die. Make no mistake, these allegations are false. Ukraine unequivocally denies them, but they also clearly involve the subject matter of the Genocide Convention. And as I will get to in a moment, they also have been opposed by Ukraine, both through its words and its actions. In December 2019, in a press release that marked the anniversary of the adoption of the Genocide Convention, the Russian Investigative Committee explained that, quote, guided by the norms of both national and international law, investigators, of course, cannot stand aside while acts of genocide are. Accordingly, it added that it was, quote, investigating crimes of genocide of the Russian-speaking population of Donbass, where civilians are dying at the hands of the Ukrainian military under targeted fire. Now, Russia claims that these statements by its investigative committee cannot form the basis of a dispute with Ukraine relating to the subject matter of the Genocide Convention. According to Russia, these statements do not represent the position of the Russian state on, quote, the international level, as the investigative committee was merely conducting a national investigation. Although yesterday Russia did concede that these investigations relate to the, quote, international crime of genocide. There is no legal requirement that statements be made on, quote, the international level. But in any event, Russia's argument that the investigative committee was doing nothing but a domestic investigation rings hollow. The investigative committee is a Russian state organ that has leveled inherently international allegations against Ukrainian officials, crimes under the Genocide Convention. And as a factual matter, the investigative committee has represented Russia at the international level, attending, for example, formal bilateral negotiations between Ukraine and Russia. And the investigative committee itself has trumpeted its allegations of genocide to the international community. For example, in 2016, the investigative committee hosted a formal presentation in English for foreign diplomats aimed at sensitizing international and foreign communities to the problem of combating international crimes in Ukraine, and they discussed the possibility of submitting evidence gathered by the Russian investigative committee to the bodies of international justice to determine the Ukrainian government's responsibility for internationally wrongful acts. Russia cannot seriously ask this court to find that it never made allegations of genocide at the international level. Beyond the investigative committee, countless Russian officials, including President Putin himself, have leveled the same accusation that Ukraine is responsible for genocide, often specifically referencing the convention. And Russian officials have explicitly referenced that these allegations of genocide justify their recognition of DPR and LPR and their full-scale invasion of Ukraine. For example, in November 2021, 3 months before Russia's recognition of DPR and LPR and its full-scale invasion, Boris Gryzlov, Russia's representative to the Trilateral Contact Group on settling the situation in Ukraine, justified Russia's support for DPR and LPR by referencing, quote, Kiev's actions which are aimed at escalating the conflict and actually fall within the UN Convention on the Prevention of Genocide. As an aside, I would note that that statement made by Russia's envoy to the Trilateral Contact Group was most certainly a statement at the international level. I also would note that Mr. Gryzlov referenced the Genocide Convention by name. Since 2014, as you have seen, Russia has alleged that Ukraine was committing genocide in violation of the convention. And at the end of February 2022, Russia went further. It took 2 extraordinary measures on the express basis of preventing and punishing an alleged genocide in Donbass. These actions were opposed by Ukraine, and these actions happened with startling speed. First, on the 21st of February 2022, President Putin formally recognized the independence and sovereignty of the DPR and LPR. In an address given on that day, President Putin claimed it necessary to take a long overdue decision to immediately recognize the independence and sovereignty of the DPR and LPR. Why? Because of a, quote, genocide, which almost 4 million people are facing in the DPR and the LPR. This was the same justification that Russia's permanent representative to the United Nations, Vasily Nebenzia, provided to the United Nations General Assembly. On the 23rd of February 2022, Mr. Nebenzia justified Russia's recognition of the DPR and LPR by claiming that, quote, in light of the blatant genocide, Russia could no longer remain indifferent to the fate of 4 million people of the Donbass. In other words, Russia justified its recognition of the DPR and LPR as a measure to bring an alleged genocide to an end. What happened the next day, on the 24th of February, 2022, is known to us all. President Putin announced his so-called special military operation, which was, in fact, a full-scale invasion of Ukraine. Yesterday, Russia was selective in quoting the speech of its president. Russia noted President Putin's reference to Article 51 of the UN Charter and its treaties of friendship with the DPR and LPR. But President Putin's speech did not end there. In his very next sentence, President Putin stated the purpose of his military intervention, the justification for his actions. And that justification was to stop a genocide. He stated, quote, "We had to stop that atrocity, that genocide of the millions of people who live there and who pinned their hopes on Russia, on all of us." Putin went on, "The purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime." The express purpose of Russia's invasion, according to Russia's president, was the prevention and punishment of a genocide that Russia alleged was occurring in eastern Ukraine. Russia transmitted President Putin's address in its entirety to the UN Security Council. Following this address, Russian officials echoed the justification for Russia's actions set out by their president. For example, this time speaking to the UN Security Council, Russia's UN permanent representative stated that President Putin, quote, "decided to start a military operation in Donbass and that the goal of this special operation is protection of a people who have been exposed to genocide by the Kiev regime." Russia's official representation to the United Nations was that its actions in Ukraine were justified in order to protect those in Donbass from an alleged genocide. The following day, on the 25th of February 2022, Russia's Foreign Minister, Sergei Lavrov, similarly justified Russia's aggression against Ukraine as, quote, "preventing the neo-Nazis and those who promote methods of genocide from ruling this country," referring to Ukraine. And in an interview that same day, Russia's ambassador to the European Union was asked about President Putin's reference to genocide as a justification for his invasion of Ukraine. The ambassador said, quote, "We can turn to the official term of genocide as coined in international law. If you read the definition, it fits pretty well." The ambassador was clear. Russia does not use the term genocide for rhetorical purposes. It uses the term as it is formally defined in international law, in other words, as that term is defined in the Genocide Convention. Ukraine did not remain silent in the face of Russia's allegations of genocide and its reliance on them to recognize the DPR and LPR and invade Ukraine. Ukraine positively opposed both Russia's allegations of genocide and Russia's steps to prevent and punish alleged genocide on Ukraine's territory. From the very beginning, in 2014, Ukrainian officials denounced the allegations of genocide put forward by Russia and Russia's investigative committee. For example, in October 2014, then President of Ukraine, Petro Poroshenko, commented on the decision of the investigative committee to open a criminal case against the military leadership of Ukraine for the alleged genocide of the Russian-speaking population of Donbass. The President of Ukraine rejected the premise of the investigative committee's case, stating, quote, "I am sure that the blow to Russian-speaking people was inflicted by the northern neighbor," pointing a finger at Russia. The Prosecutor General's Office of Ukraine also stated that the investigative committee's actions were, quote, "groundless." And one of the Ukrainian officials accused by the investigative committee, then Minister of Defense, Mr. Valery Zhelety, publicly rejected the committee's allegations. He stated, "Regarding the criminal case against me and my colleagues in Russia for genocide of the Russian-speaking population, this whole thing is a complete delusion. Minister Helety added that, quote, only crazy Kremlin propagandists can accuse the Ukrainian army, which is 40% Russian-speaking, of hating other Russian speakers. Minister Helety's sentiment was echoed by advisors to the Ukrainian Minister of the Interior, who also denounced the actions of the investigative committee as nonsense. As one advisor responded, quote, I have to tell you that commenting on another nonsense of the investigative committee of the Russian Federation is a thankless task, especially when they use terms like genocide. In November 2015, following additional allegations of genocide by the investigative committee, Ukraine's Speaker of the Presidential Administration on Anti-Terrorist Operational Issues explained that the Russian side is fabricating data about Ukraine's alleged genocide of the Russian-speaking population in Donbass. In an effort to undermine the relevance of these Ukrainian statements refuting Russia's allegations of genocide, Russia argues that these Ukrainian officials do not have authority to represent Ukraine's position at the international level. Further, according to Russia, Russia could not have been expected to be aware of these statements. In other words, Russia looks for any way it can to say that Ukraine did not actually oppose Russia's baseless view that Ukraine was committing genocide against its own people. But these efforts by Russia to ignore evidence of a dispute between the parties falls flat. Ukraine has presented numerous examples of statements made by Ukrainian officials, including Ukraine's president and its Minister of Defense, rejecting Russia's allegations. These statements were reported on government websites, in the press, and on social media. Russia could not have been unaware that Ukraine opposed its allegations of genocide. To this day, the investigative committee continues to levy accusations against Ukrainian officials. Ukraine, already on the record opposing these allegations as fabrications, nonsense, and a complete delusion, saw no need to give Russia's propaganda more legitimacy by continuing to condemn Russia's allegations. Ukraine's position was clear. And then, in late 2021 and early 2022, as Russia amassed troops along the Ukrainian border, its alleged allegations of genocide took on a new and more sinister significance. Russia's propaganda machine was in full swing. Ukraine responded. On the 26th of January 2022, the Information Agency of Ukraine's Ministry of Defense published an article responding to Kremlin propaganda myths in which it stated, quote, there is no evidence that Russian-speaking or ethnic Russians in eastern Ukraine are persecuted, not to mention genocide, by the Ukrainian authorities. On the 23rd of February 2022, at the same UN General Assembly meeting where Russia's permanent representative to the United Nations claimed that Russia's recognition of the DPR and LPR was in response to a blatant genocide, Ukraine's Minister of Foreign Affairs, Dmytro Kuleba, denounced Russia's accusations against Ukraine as absurd. Russia is critical of the fact that Minister Kuleba's statement did not explicitly refer to genocide or the Genocide Convention. But while Minister Kuleba chose not to amplify Russia's accusations of genocide, he very clearly and forcefully defended his government's actions in Donbass and condemned Russia's illegal recognition of the DPR and LPR. And the next day, Russia launched its full-scale invasion of Ukraine, the purpose of which, according to President Putin, was, and I quote, "to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime." Russia acted on a purported right under the Genocide Convention to use force to prevent, punish, and bring to an end an act of genocide in Ukraine. Russia immediately opposed Russia's reliance on allegations of genocide to invade Ukraine. Ukraine opposed Russia's position with a sense of urgency as bombs rained down on Ukrainian cities and Russian troops invaded from the east, the north, and the south. Ukraine did first and foremost through its actions. Ukraine resisted Russia's purported fulfillment of the Genocide Convention in the strongest terms, defending its territory and its people, including in the Donbas region, from Russian aggression. Was Ukraine protecting its territorial integrity? Absolutely. But in doing so, Ukraine was also rejecting the notion that Russia had the authority to use force in and against Ukraine to stop a genocide. In this case, as in Bosnian genocide, which also involved an ongoing armed conflict, the parties' conduct demonstrates a dispute relating to the Genocide Convention. At this point, there was a dispute between the parties relating to the Genocide Convention that included Russia's reliance on its fabricated allegations of genocide to justify its recognition of DPR and LPR and its full-scale invasion of Ukraine. The opposing positions of the two states had been established by the statements and the conduct of each party, and no further action was required by either Ukraine or the Russian Federation to bring the dispute within the ambit of Article 9 of the Genocide Convention. Lest there have been any doubt, however, Ukraine reiterated its opposition before filing its application with this court. In a statement by Ukraine's Ministry of Foreign Affairs, published on the 26th of February 2022, on the third day of Russia's full-scale invasion and prior to filing Ukraine's application with this court, the Ministry of Foreign Affairs again rejected Russia's narrative, publishing a statement on Russia's false and offensive allegations of genocide as a pretext for its unlawful military aggression. In this statement, the ministry explained that, quote, Ukraine strongly denies Russia's allegations of genocide and denies any attempt to use such manipulative allegations as an excuse for unlawful aggression. The ministry went on, the crime of genocide is defined in the Genocide Convention, and under that convention, Russia's claims are baseless and absurd. Russia's claims of genocide as justification for its lawless conduct are an insult to the Genocide Convention and to the work of the international community in preventing and punishing the world's most serious crime. The ministry called on Russia to immediately cease aggression against Ukraine taken under this pretext. Russia claims that Ukraine's statement was imprecise or vague, but that's disproven from the statement's plain language. As to timing, given the fast pace at which Russia's full-scale invasion was unfolding, with Russian troops attempting to take Kiev and bring down Ukraine's government, the timing and manner of the statement's publication do not detract from its relevance in confirming that there is a dispute existing related to the Genocide Convention at the time of Ukraine's application to this court. It is common ground that Ukraine published this statement prior to filing its application. It is reasonable to presume that in the circumstances of war, the Russian Federation would have been closely monitoring any official statements from Ukraine's Ministry of Foreign Affairs. Finally, I would direct this court's attention to the subsequent conduct of the parties in this case. In the Gambia versus Myanmar, the court observed that, quote, conduct of the parties subsequent to the application may be relevant for various purposes, in particular to confirm the existence of a dispute. After Ukraine's application, and after the court indicated provisional measures in this case, the Russian Federation maintained its claim that its actions in and against Ukraine are based on bringing an alleged genocide to an end. In remarks given on the 18th of March 2022, just 2 days after this court indicated provisional measures, President Putin reiterated that people in Donbass were subject to genocide, and he claimed that, quote, "The main goal and motive of the military operation that we launched in Donbass and Ukraine is to relieve these people of suffering of this genocide." Just this summer, the Secretary of Russia's Security Council explained again that, quote, "The special military operation has specific goals, and that Russia is, quote, saving the population of the DPR and LPR from the genocide that has been carried out by Ukrainian neo-Nazis for 8 years. If any possible doubt remained, it was put to rest 2 weeks ago by a statement by Dmitry Medvedev, the Deputy Chairman of Russia's Security Council, and formerly Russia's President and Prime Minister. Medvedev stated, "The UN Convention on the Prevention and Punishment of the Crime of Genocide states that genocide is understood to mean acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. This is exactly what the Kiev regime has been doing since 2014. Medvedev went on, using a derogatory term meaning Ukrainian scum, and I quote, "The convention also states genocide must be justly punished. Ukrainian scum who are guilty of killing civilians in Donbass will receive a well-deserved punishment for everything they have done. That is why the special military operation must go on until its goals are fully achieved." That's a chilling statement, but it is also quite clear. To conclude, since 2014, the Russian Federation has accused Ukraine and its officials of committing genocide in Donbass in violation of the Genocide Convention. Ukraine called such allegations a complete delusion. But Russia did not back down. Instead, it relied on those allegations of genocide to justify its recognition of DPR and LPR and to launch a full-scale invasion of Ukraine. Ukraine protested vehemently. It protested before the UN General Assembly through statements by its Ministry of Foreign Affairs and by fighting against the Russian incursion. Russia, to this day, continues to allege that genocide justifies its war. It continues to invoke the subject matter of the Genocide Convention and to even call out the Genocide Convention by name. Madam President, members of the Court, the facts speak for themselves. There is a dispute between these parties relating to the Genocide Convention, and Russia's first preliminary objection